Professor Kyritsis Dimitrios from the University of Essex, England.
Good morning, everyone. Thanks so much for joining in. Thank you for the very kind invitation to what promises to be an intellectual feast. You put together an amazing set of panels. So the topic of my talk is legislative intent and authority. I want to look at this relationship by examining what I take to be an influential jurisprudential view. And according to that view, legislators' intentions are key to statutory interpretation because the enactment of statutes is an instance of communication, and therefore their meaning, their legal meaning, the legal rights and duties that flow from statutes is determined by the speaker's intention, communicative intentions, in this case, the legislator's communicative intentions. This view, which I'll call the factual view for reasons that I hope will become evident in a minute, can be said to find support in the notion of practical authority. If legislators are vested with authority to make law by enacting statutes, the law these statutes give rise to must be the law that the legislators intended to make. And it is this alleged connection between practical authority and legislators' intention that is my topic here. I want to put pressure on this connection by looking at the role that the view I've just outlined, which the factual view, by looking at the role that the factual view assigns to moral considerations in statutory interpretation. And to this effect, I will examine how such considerations play out in a doctrine of statutory interpretation from UK public law. The doctrine is called the presumption of legality. I shall argue that this presumption puts pressure on some of the key premises of the factual view because there's no facts either about the intentions of the legislators or about the context within which they communicate them, which can explain how that presumption operates. Now, if the factual view is hard-pressed to explain UK law with its adherence to parliamentary sovereignty, then that in itself should give us pause. However, I want to go further, if I have time. I want to claim that the factual view's failure to explain the presumption of legality also casts doubt on the connection between legislative intent and practical authority that it relies on. It attests to a broader failure to account for the authority relationships in legal systems with courts and a legislature such as the UK. Now, let me briefly outline the main tenets of what I call the factual view. According to it, the legislature forms an intention to deal with a political issue in a certain way, and then conveys that intention to the legal subjects in the form of the text of a statute. In other words, by enacting the statute, the legislature communicates its intention to effect a change in the law. On this view, the statute can be treated as any other instance of linguistic communication in order to determine its meaning, by which I mean its legal meaning, the rights and duties that flow from it. We must look at what was communicated by it. And in order to determine what was communicated by it, we must look at what the legislature had intended to communicate. Now, we should note that this inquiry is meant to uncover a complex descriptive fact, namely that a collective body intended to communicate its view about how to deal with a certain issue, regardless of whether that view is morally appropriate or not. Now, so far I've outlined how the factual view establishes a connection between intention, legislative intention, and communication, but this is not our topic yet. I said that I wanted to explore the connection between legislative intent and the legal meaning of a statute. So how do we move from communication to legal norms? Now, the answer to this question cannot come from the theory of language. If legislative utterances have any bearing on our legal rights and duties, it must be because law assigns this role, in the same way that the words, "I promise you I will fie," create moral rights and duties insofar as the morality of promising says that they do. Now, so where should we look for the jurisprudential basis of legislative intent's role that the factual view champions? Joseph Raz famously contends that that jurisprudential basis can be found in the concept of authority. Legislatures have or claim to have practical authority, by which we mean the power to tell us what we ought to do. They exercise this power by making laws. Through them, they communicate how they intend that legal subjects ought to behave. Now, what does this view tell us about the connection between legislative intent and the legal meaning of a statute? I'm quoting Raz here. To give a person or an institution lawmaking powers is to entrust them with the power to make law by acts intended to make law, or at least undertaken in the knowledge that they make law. That's the end of quote. For the power to exist, however, it is not sufficient that it be exercised in a certain way by acts intended to make law. Rather, it must also be true that the person or institution is thereby put, and again I'm quoting from Raz, in control over the development of an aspect of the law, end of quote. Such developments must reflect the lawmaker's choice rather than someone else's. Legislation, says Raz, is not the product of an invisible hand mechanism, but a deliberate act. So it matters immensely that the law produced by it reflect the view of the person charged with legislating. As much, it seems, flows from the logic of authority. Arguably, if the legal meaning of a statute is the content communicated by the legislature that enacted it, as the factual view maintains, that control and hence also legislative authority are vindicated. For Raz, this is again, I'm quoting from him, the best general argument in support of the factual view. And in what follows, I shall focus on it. Now, let me just elaborate a little bit. Through the lens of Raz's theory of authority, the factual view appears to involve a two-stage process. At the first stage, morality may call the shots, at least as far as legitimate legal orders are concerned. In those legal orders, a moral story will pick out the legislature as a practical authority, perhaps on the basis that we're more likely to conform to right reason by following its directives, or because of its democratic credentials, its deliberative capacity, the fact that it can facilitate coordination. There's a long list. But once morality vests authority in the legislature, it withdraws from the scene. At the second stage, social facts take over. That is because authority is exercised by the issuing of a directive, which is a social fact, fixed in history, independent of our opinions about proper legal or constitutional practice. It may be difficult to ascertain its meaning, but the difficulty is not moral. What we want to know is what the legislature communicated, not what it ought to have communicated. Okay, so much for the factual view. I find the picture that it paints of the relationship between the content of the law, or the legal meaning of a statute, and language unconvincing. And my doubt is motivated by the fact that, at least in the legal systems that we're most familiar, the legislature is not the only body that speaks on the law's behalf. Arguably, in order to ascertain the contribution that the legislature makes to our legal rights and duties, we ought to examine the interplay between the legislature and the other main players in the constitutional order, such as the courts, who may have the power to alter the impact of a statute. So in what follows, I shall argue that this interplay spells trouble for the factual view, and to dramatize institutional interplay, I shall use, as I said, an example from UK public law. Now, with its adherence to the doctrine of parliamentary sovereignty, UK public law seems at first blush to vindicate Rice's picture of legislative authority, but appearances can deceive. Westminster's legal preeminence is tempered in a number of ways, and one of them is the so-called principle of legality. And the principle of legality includes a presumption. It's a presumption controlled by the courts that Parliament does not intend to legislate contrary to human rights. This is by the way, this is a presumption that predated the Human Rights Act. It's anchored in the common law, not in statute. The presumption can be defeated, but only by the use of clear and unambiguous language endorsing the right-infringing effects of the statute. It's the courts that will determine whether the statute does include such clear and unambiguous language. Now, how can proponents of the factual view account for the presumption? I shall examine two strategies. According to the first strategy, statutes need not be understood as settling or purporting to settle every issue that they raise. Legislatures may opt for what Andrei Marmor has called tacitly acknowledged incomplete decisions. Such decisions trigger that most famous of positivist panaceas, judicial discretion. In essence, what they amount to is a delegation of power from the legislature to the judiciary. It is now up to courts to fill out what the legislature has left incomplete. Even more importantly, what triggers the presumption is not what legislators thought would be the implications of the statute they enacted, but what judges interpreting the statute now think. Now, here's the problem with this strategy. The operation of the presumption, as I've described it, allows that it may be invoked by courts in unanticipated circumstances, at least unanticipated by the legislators that enacted the statute. Now, if that is the case, it does not seem plausible to claim that whenever courts invoke it, they're implementing a legislative decision, even a tacit one. So much for the first strategy that invokes the notion of judicial discretion. Does the second strategy fare any better? The second strategy assumes that due to its general practice by UK courts, the principle of legality has ossified into a maxim of communication. Because legislators know or should know the presumption of legality, the principle of legality, we can reasonably attribute to them the intention to communicate in accordance with it. After all, the factual view refers the courts to the conventions of interpretation prevailing at the time of legislation. These conventions, I'm quoting from Raz, form the context in which the legislature's intention was framed, and therefore inform the intention it sought to convey in issuing the statute in the particular form in which it was adopted, end of quote. Importantly, these conventions govern what content can be inferred from a legislative utterance by way of a conversational implicature. Okay, so that was the second strategy. The operation of the principle of legality amounts to a maximum of conversation that creates conversational implicatures. What stands in the way of this maneuver is the pervasive and highly controversial nature of human rights questions. When it comes to our fundamental rights, there clearly are no standard expressions in natural language that are commonly understood to signal the legislature's preference for the rights-consistent interpretation of its utterances, and no context where the presumption is generally agreed to apply. A legislator may have chosen general and unqualified language, not because she intended her words to be given a rights-consistent interpretation, but because she did not think her provision engaged a right at all. If so, the legislator may not even have contemplated that she needed to expressly and clearly signify her preference for a particular version of the impact of the statute she was enacting. Given the difficulties that both strategies run into, I think it is much more natural to suppose that in applying the principle of legality, courts are not in the business of giving effect to a legislative intention, whether it be a tacit delegation of power or an intention in the shadow of a conversational implicature. Rather, courts make their own moral judgment that qualifies the impact of the statute they're interpreting. They therefore take on a more active role than the factual view supposes. Are they thereby acting in blatant disregard of the statute they're interpreting? Well, their practice seems to fly in the face of the best general argument, Rice's theory of authority. But the best general argument misconstrues the authority relationships in legal systems like the UK with the legislature and courts. In those legal systems, the element of control that legislators should reasonably expect to exert over the content of the law through their intentions is very considerably qualified. To be sure, legislators in such systems intend to legislate. They intend to make their distinctive contribution to the project of governing that they share with the courts, and they communicate that intention to the addressees of legislation. So much I'm not contesting. What I am saying is that these intentions are a far cry from the intention to make the law that the legislature intends to make, that Rasen talks about. Again, this does not mean that legislators lack authority. It simply means that authority, at least in legal systems like the UK, is not best captured by the best general argument. Let me elaborate. Given that the legislature's efforts to enact law are frequently and properly modified or even frustrated by courts operating, let's say, the presumption of legality, it would be unreasonable of the legislature to stick to having an intention to make the law it intends to make. In any event, if the legislature insists on having such an intention, the rest of us can routinely ignore it. It seems much more reasonable then that, seeing its place in the constitutional order, the legislature retains a relatively modest intention when it legislates. That is, an intention merely to contribute to the content of the law, knowing full well that its contribution will be combined with the contributions of its institutional partners. In addition, this stance on the part of courts, for example, in the face of a legislative decision, does not betray insubordination. Even though they do not take legislative intentions as eo ipso binding, courts still maintain their allegiance to the joint project of governing as a whole. In fact, when they exercise independent moral judgment in figuring out the meaning of the statute, courts are affirming rather than negate the authority of the joint project. Their supervisory function is one of the constitutive elements of legal authority in legal systems with a legislature and courts. Okay, let me conclude. The argument I've presented is motivated by the conviction that you cannot evaluate different accounts of statutory interpretation without recourse to the theory of political and legal authority. And conversely, you can productively evaluate different accounts of legal authority by exploring their implications in statutory interpretation. Now, if I'm right in the way I've cashed out doctrines such as the principle of legality in UK public law, so in terms of moral considerations that have little to do with communication, then it is not only a certain style of thinking about law and language that is in trouble. Our understanding of authority needs to be revisited as well. Thank you very much.